Awoni Alabi, you're welcome, sir.
Thank you very much.
This is Newsmaker.
Thank you for having me. Thank you.
Yes, we want to look at the issue that is trending, a particular figure in politics clamoring for the transmission of the tribunal, that is at the presidency, live. Then what is the stand of the law about it?
Well, thank you very much. We must know, first of all, that the court of law is not a secret court.
Okay.
And whenever the court sits in the open court, that is the public in the eyes of the law. And depending on the situation, whoever is interested in watching the proceedings will be allowed to sit at the gallery while the lawyers will sit at the bar. So a court of law is a public place. And live transmission, this and that one will depend on the position of the court, because the court is always in control of what happens before the court. It depends on the argument of the proponent of the live transmission of proceedings. Maybe he's been subjected to an application. He must have sworn to an affidavit stating the reasons why he feels it should be done. Then the other party also have the right to either support it or counter it by way of counter affidavit, and they will support their respective positions with the relevant principles of law. And whatever the court determines at the end of the day will be final, because like I said, the court is always in control of its proceedings, and no litigant has a right to dictate to the court the way and manner the court should go about its proceedings. So I have a feeling that step may be unnecessary. To me, it may amount to playing to the gallery, because these people have been going to court over the years. This is not the first election petition that will happen in Nigeria. Most of these people have been involved in election petition matters before, where they were parties. So I don't know what they want to achieve, but if by the time the court listens to them, if the court feels their application is competent, is meritorious, the court will grant it. If not, the court will refuse it. And it does not make any difference anyway. Like I said, no litigant has the right to dictate to the court how the court will conduct its proceedings. And number two, whenever the court sits in the open court, that is the public. So there are situations where the court may decide to sit in camera. What do we mean by that one in law? The court, the presiding judge or justice will just call the parties and the lawyers into his or her chambers. That's the one we call sitting in camera. So anytime they come
without the real camera,
without the real camera and without exposure to the public. You know, the court premises is a public place. The courtroom is a public place in the eyes of the law. So the court is sitting, the tribunal is sitting in the public already, because we've not had, at least we have been having clips of the proceedings by television, this and that. That means they can capture it. So I don't know what they want to achieve by saying they should televise it. I wouldn't know, depending on the position they have submitted to the court. But like I said, no litigant can dictate to the court the way and manner to go about its proceedings. And if the court feels, depending on the facts placed before the court, what do they want to achieve? If the court feels, okay, it's justifiable, it may allow it. If he does not allow it, it doesn't make any difference.
When we compare that of the Kiri Madu's case that is in the UK
Yes.
to what we have been having in Nigeria, you discover that firstly the judge on that day, we saw him physically and we saw almost everybody in the court. But in Nigeria here, why our judges are always hidden?
Judges are not hidden, like I said. Well, it depends on, you see, in our country, yes, our country may be unique in certain negative ways. When you see a country, a litigant has submitted his grounds or grievances to the court, believing the court will sit over it, and even before the court is empaneled, the same litigants have gone back to the town, to the street, demonstrating, suggesting what is likely to be, the court should do this, the court should do that. Those things don't happen.
Freedom of speech.
Those things don't happen in civilized climes. Are you trying to prejudge, or like people have said, are you trying to intimidate the judiciary? So if you knew from the word go that you didn't have confidence, why did you take your matter to them? You know, it's strange. It's strange. At times it may lead to contempt of court. In civilized climes, those acts, misconduct, amount to contempt of court. We call it contempt ex facie curiae. It's outside the court. It's not done in the courtroom, but it's been done outside.
It's a crime also?
Of course, yes. It's a criminal.
Irrespective of the number.
It's a criminal offense for which the court can order the arrest and commit them to prison.
No matter the number.
Because, yes, you have submitted your matter to the court. In other words, you are now saying that except the outcome of the proceedings result in your favor, you will not believe it. You know, I can't understand that kind of thinking. Why do you have to be terrorizing the public, terrorizing the judiciary? You have submitted it to it. Well, of course, even before you started the electioneering campaign, an African politician knows what goes along with politicking and politics. So many things. If you step out to contest for an office, you must be thinking of either of two things. It's either you win or you lose. And if you lose, and you want to submit it to the appropriate authority, charged with the responsibility of resolution of disputes, have two things in mind. It is either you win or you lose.
Yeah.
And either way, heavens will not fall. Whenever 2 or 3 go to court, only one person will win. Some other person will lose. Not until when we have that understanding, we will not be having all this carried going all over the place. The court sees today, they will be commenting on it. If you don't do this, if you don't do that. Some, even from some of our people from overseas, this is the test for the judiciary. Test for what? Is it the only case? Are there no other cases? What about chieftaincy cases in court? What about cases on land matters? What about cases on banking and all kind of things? Are there not cases? It is because we have elevated election petition over and above the rights of all other people, which is very wrong. It's like every other thing. It's like I have a piece of land, somebody wants to take it from me, I go to court. It's not different from that. So, but politicians will always do their things in different ways. That's the way I see what is happening.
And okay, then when somebody feels when they allege the court that the court is not doing the just, then when somebody wins, they always credit. That is yes. But I want to look at this angle. When will Nigeria stop going to the court? Because some people even before the election, they have set They have set litigation. They have set some cases that they are going to the court. If they lose, then when are we going to stop all this from that? When somebody fails or loses an election, the person will take fit, or when somebody wins, you just appreciate the voters.
Well, let me say this: you can't stop people from going to court, not only in elections, because human beings, we are basically gregarious, we are conflictual, militancy here and there, and that was the genesis of the institution of court. If there are no conflicts, there wouldn't have been any need for court. But because of our nature as human beings, we don't seem to agree on so many things. And so, for there to avoid a state of anarchy, that's why there's an institution called the court to resolve dispute. But things we can talk about are things that can reduce litigation. The factors that can reduce litigation include, it will start from the recruitment of candidates for elective offices. Our politics in Nigeria is party-based politics. If you want to run for an election, you must belong to a political party. Now, at the level